One of the really important divisions of the court is the registry. That is the place that all requests for a trial will arrive. It registries, and I believe it's the same in Russia, but in the US, in United Nations, in all of the international domestic courts, are the place that the administration of the court is centered. So requests for a hearing will arrive first to the registry. So they have the function of organizing and laying down the rules of the court. When sitting in a single judge formation, the court shall be assisted by rapporteurs who shall function under the authority of the president of the court, and they form the part of the court's registry. So the judges have representatives within the registry, and there are decisions within the registry on the processing. If there is something, a document, a request for a hearing that is incomplete, that issue will be raised immediately at the registry. At that point, the registry can stop a case from proceeding. So the registry, in terms of individuals or NGOs bringing cases, is in fact probably your most important first hurdle. The plenary court. The plenary court elects its president and vice president for a period of 3 years, and they can be re-elected. This is the first set of chambers that a case would have to go through to be heard. As I mentioned in the start, we're going to move on to a slide that shows the exact process, and it is a very, in the tradition of Europe and Napoleon, a very bureaucratic and numerous levels that you have to proceed through at the European Court of Human Rights to ever reach a judgment. The plenary court sets up chambers, which are constituted for a set period of time. It elects the president of the chambers that may be re-elected. It also adopts the rules of the court. It elects the registrar and one or more deputy registrars. And any requests under Article 26 will go through the plenary court. So the plenary court is a branch of the registrar, and it really deals with the administration of the court. It is not dealing with decisions on specific cases. As we'll see, that goes later. So to consider cases brought before it, the court sits in a single judge formation in committees of 3 judges, in chambers of 7 judges, and at the top, sort of as a Supreme Court, you would say, at least in the United States, it would be a federal Supreme Court or a state Supreme Court, is something called a grand chamber of 17 judges. So this is the hierarchy. The court chambers will set up committees for a fixed period of time. At the request of the plenary court, the committee of ministers may, by a unanimous decision and for a fixed period, reduce to 5 the number of judges of this chamber. When sitting as a single judge, a judge shall not examine any application against the high contracting party in respect of which that judge has been elected. So the judges are elected, and they're put in positions nominated by their countries, elected by the countries, and then cannot be removed unless there's a case brought for something such as perhaps ill health, where they're not able to appear, or if there's any sort of bias shown. So if you're able to prove, for example, that a judge has a business involvement, or perhaps, and I will be honest in this in saying in the UN courts, there have been instances where they were able to show money being transferred into a judge's account. So that judge was removed by one of the parties that he was hearing. So that judge was removed for corruption. Anything like that can excuse a judge from sitting. Article 26 of the European Convention, single judge formation committees, chambers, and grand chambers. There sits ex officio, a member of the chamber and the grand chamber, the judge elected in respect to the high contracting parties. If there is none, or if that judge is unable to sit, a person is chosen by the president of the court from a list submitted in advance by the party that sits in the capacity of a judge. The grand chamber, which again I will refer to as almost a supreme body of the court, also includes the president of the court, the vice presidents, the presidents of the chambers, and other judges chosen with accordance to the rules of the court. The grand chamber is the final chamber that would hear any sort of appeals and issues the final decision. It is unusual that a case moves all the way through to the grand chamber. And it does consist of the most senior judges at the European Court of Human Rights. When a case is referred to the Grand Chamber under Article 43, no judge from the chamber which rendered that judgment shall sit within the Grand Chamber. So if a decision has progressed all the way through to an appeal to the final stage of a hearing, the Grand Chamber, the earlier judges, the prior judges, there's no ability for them to rehear that case. They cannot be involved in any sort of an appeal or any sort of a final decision, because it's very possible, and this has happened once we start going through the cases, that cases are overturned. So there might be a finding in a lower level of the European Court of Human Rights, but what happens and what is the final resolution is what is decided in the Grand Chamber. So each single judge at any level may declare inadmissible or strike out of the court's list of cases an application submitted under Article 34, where such a decision can be taken without further examination. The decision shall be final. If a single judge does not declare an application inadmissible or strike it out, that judge shall forward it to the committee for further examination. So it is possible, and this is almost always on a technical reason, that in a lower level of the court, prior to reaching the Grand Chamber, that something has been done incorrectly. For example, when we get to an examination of how cases progress, if a domestic court has not heard all the way to the final conclusion the argument that has been brought to the European Court of Human Rights, that case will be thrown out. If anything has violated, if any of the lawyers bringing forward a case to the European Court of Human Rights have violated one of the rules, that case will again be thrown out and will not have the ability to progress all the way to the Grand Chamber. So while we all would love cases based on merit without any of the details of administration to be heard, oftentimes it is an administrative error. And I will say most of the times in the European Court of Human Rights, it is an administrative error, which is the reason that a case stops being heard. So it is essential that anybody, any group, any NGO that is bringing a case follows very strictly each of the rules that the European Court of Human Rights lays out. So I would say that almost the most important thing in order to getting your issue heard is that you follow the bureaucracy, that you follow each of the specific steps, or your case will be thrown out and it may not have any admissibility afterwards. I did hear, and this is now completely rumor because we had spoken to one of the lawyers involved in the Pussy Riot case, that one of the earlier hearings, one of the earlier lawyers' attempts to bring that case had been dismissed based on an error, an administrative error. Again, when we get to the United States and we examine the Alien Tort Statute and ways that you can bring human rights cases in United States courts, you're going to be feeling very free because a lot of these administrative rules are not there. And when they are breached, you will always have a second chance and a third chance to re-enter the court system and refile. That this finality of the European courts is an unfortunate Napoleonic bureaucracy, which is keeping the court from hearing a lot of cases. In respect to an application that is submitted under Article 34, a committee may, by unanimous vote, declare it inadmissible, or strike it out of its list of cases, or such decision can be taken without further examination. I almost feel I should have done the prior thing, the prior slide. But when a case comes in, it will be arriving at the registry, and we'll see this in a moment. At the registry level, that is where you will usually have to go through the most hurdles. You will have to prove that your case has been heard by each level of your domestic court and rejected, and you will have to show that you have filed everything correctly with the European Court of Human Rights. If for some reason you have managed to get through that hurdle, through the registry, and arrived at the first level of judges, it is possible still there that they will spot something, that they will see there is a reason, administrative reason, or for perhaps the area of law does not fall under the European Court of Human Rights. It may not be considered a human rights issue. And then they will dismiss it. So they can just declare it admissible and they can declare it admissible and render at the same time a judgment on the merits. If the underlying question in the case concerning the interpretation of the application of the convention or the protocols is already the subject of well-established case law of the court. So in this first level of the European Court of Human Rights, if a similar decision, if it is case law that has already been decided by the court, the judges will make a decision that is final, and it is based on your case having met already the facts and the law that the court has already judged upon. So you will be completed. Your decision will be rendered at this level based on the fact that the judge and that the European Court of Human Rights has already examined this issue. Your case falls under this issue, and it is decided under this issue and under the law that the court has established. These decisions, when they're already based on established case law of the court, are final. They will not progress to the next level. So unfortunately, if your case law works against you and it has already been decided, you will not have a right to go further in the European system. You will be receiving a final decision. If the judge elected in respect to the high contracting parties is not a member of the committee can invite that judge to take place of one of the members of the committee, and this is just an administrative rule, including whether the party has contested the application of the procedure. So it is possible for another judge to jump in if one is removed, or if there is some sort of reason that one of the judges cannot be part of that this decision. So under Article 28, a chamber can decide on the admissibility and the merits of individual applications. The decision on admissibility may be taken separately. A chamber shall decide on the admissibility and merits of an interstate application under Article 33. The decision on admissibility shall be taken separately unless the court in exceptional cases decides otherwise. So as I mentioned, again, this is just a repeat, that once it's gone through the administrative requirements of the registry, the first level chamber can decide whether these issues have been heard before, whether it's case law set by the European Court of Human Rights, which has already decided this, and can decide whether your case is admissible and can proceed to the next level. The Grand Chamber. The Grand Chamber is, again, the highest level of the European Court of Rights. Where a case pending before the chamber raises a serious question affecting the interpretation of the convention or protocols thereto, or the resolution of a question before the chamber might have a result inconsistent with the judgment previously delivered by the court, the chamber may at any time move forward. If no decision is taken under Article 27 or 28, and there's no judgment that's been rendered, it may go to the Grand Chamber. So just like if you think of the United States Supreme Court, Just like the United States Supreme Court, the Grand Chamber can only decide new case law. If there's any sort of issue concerning an interpretation of the European Convention of Human Rights that has not been examined before by the European Court of Human Rights, that is the only time it will move towards the chamber. The chamber is the final place of resolution of any case before the European Court of Human Rights. And again, it's the final arbiter on European human rights law. Powers of the Grand Chamber. The Grand Chamber determines the applications submitted when the jurisdictions has been relinquished. So it is possible, although very, very, very rare, that a case can proceed all the way to Grand Chamber, and the Grand Chamber can find that somewhere prior in the steps that it never should have arrived, and it's sent back, and the final decision would be the chamber prior to that, before it had reached. So that is the final decision prior to arriving at the Grand Chamber will be the final decision that remains. So again, if it was a technicality that kept it, or for example, the Grand Chamber just determines that it has been heard before, even though the prior chamber felt that the case had not and did raise the substantial questions of European human rights law, the Grand Chamber has the final decision on that. It's the final arbiter, and it can turn back the case and say, we have heard this issue. This is not a new issue that's being raised, so we do not have the jurisdiction. And the final decision of the European Court of Human Rights is the one that will stand. It decides on issues referred to the court by the Committee of Ministers. So the rules set by this court, by the European Council, by the European Convention on Human Rights, is the final legal jurisdiction of the Grand Chamber. It also asks for advisory opinions, and this is interesting under Article 47. So it is possible for countries, for NGOs, to submit final advisory opinions. So if the European Council believes that there's a substantial issue that is at stake, they can submit an advisory opinion to the Grand Chamber saying, for example, this case in Poland raises substantial issues of the European Convention of Human Rights, and we believe that it should be heard for list, and it would list the cases, list the legal reasons. One other thing, and I believe I'll get to it, but I may not, there is a point throughout all of this at each level of the European Court of Human Rights hearing cases for amicus curiae briefs to be submitted. And again, I don't know how much legal background each one of you has, but put very simply, an amicus curiae brief is a brief which is a friend of the court. So let's say, for example, in the case of, I think it was in the case of Pussy Riot, a number of human rights organizations, Amnesty International, submitted briefs, legal briefs and documents stating why the case should be heard by the European Court of Human Rights, and stating exactly the human rights law issues that the case raises. So in fact, you as an NGO, if you're representing an NGO, it is possible, if you're not bringing a case before the European Court of Human Rights, if you become aware of a case that's gone to the Grand Chamber, or maybe that is in a midpoint chamber of the European Court of Human Rights, for you as an NGO to submit a brief. So you could have a number of lawyers, let's say it's an LGBTQ issue that's raised in Romania, let's say, hypothetically. An NGO from any country can submit briefs at any point to support either the legal issues of we believe that this case should be progressing forward to the Grand Chamber, that it raises essential issues of European human rights law, and we support that. Or you can also write an amicus curiae brief in support of a specific issue. So let's say the country at question, let's say Romania, the case had gone through all of the stages of the Romanian courts, and one of the issues was not considered a human rights issue. As an NGO working in LGBTQ issues, you may spot issues which you consider to be human rights issues, and you can draw that, especially, specifically if it fits within European Convention's human rights definitions, you can bring that as a brief to any stage of the European Court of Human Rights. Especially, and you will find that most Amnesty International, Human Rights Watch consistently are filing human rights briefs. We will go through a case called Orsic v. Croatia, which was a case specifically about the legal rights of Roma children to attend Croatian schools. They had been pulled out and put in specific schools. Croatia established schools for Roma gypsies, and Amnesty International followed that case from the start and was filing briefs all along the European Court of Human Rights channel at every single point. The European Court of Human Rights decided in favor of the Roma population and against Croatia. Croatia did nothing. And nothing happened on the ground, which you'll see, which is one of the issues we're going to have to deal with. The European Court of Human Rights is implementation of the decisions. And Amnesty International has not stopped. They're filing things in Croatia right now. They're filing things in Europe, in front of the European Council, demanding that Croatia implement the decisions. So the power of the NGO, if at a minimum to draw public interest, to draw media interest, there's enormous power for the NGOs throughout the European Court of Human Rights process, from beginning all the way through to implementation. Article 32, jurisdiction of the court. The jurisdiction of the court shall extend to all matters concerning the interpretation and application of the Convention and the protocols, which are referred to and provided in Articles 33, 34, 46, and 47 of the European Convention of Human Rights. I believe Victor has provided that to you. So the most important document for you to have before looking at any of the cases that come before the European Court of Human Rights is the European Convention of Human Rights. And as I've stated, European Convention of Human Rights is a development that comes from the Universal Declaration of Human Rights. And I will make sure to pull and put maybe in some sort of Google share all of these documents. After you examine the United Nations Declaration of Human Rights, the European Convention of Human Rights, your third step, and one of the most important steps, is that you familiarize yourself with case law of the cases that have appeared before the European Court of Human Rights. Because as I've been mentioned through the prior slides, if a case has already been heard that deals with issues similar to the case that you're bringing or that you're supporting, the European Court will not evaluate or question that case law. So if there is a dispute whether the court has jurisdiction, it is the court that shall decide. And that jurisdiction issue is usually resolved at the level of the registry, but as I've said, it can go all the way, if it is, for example, a very nuanced and unclear matter of jurisdiction, it can go all the way to the Grand Chamber, turning back a case and saying, we're sorry, this case does not fall under our jurisdiction. This case has some minute similarity, which makes it which signifies that it's already been decided by the court, and we will refuse to rejudge, to re-examine this case, the issues in this case. Article 33. Any high contracting party may refer to the court any alleged breach of the provisions of the convention and protocols thereto by another high contracting party. So there are cases of interstate. So it is possible, for example, for France to raise issues with Poland, which is specifically going on now, to say that this country has breached rules of the European Convention of Human Rights. It is not always necessary for an individual to bring a case. It can be referred by a member of the European Convention. Now, it's possible for both things to happen, for an individual in Poland to raise the issue and to begin the filing and the processing of the case, and for the high contracting party to come in in support of that individual. But if there is no individual in a country, or if the country is one that has, let's say, very restricted in terms of media, in terms of people being able to speak and come to file something, and they fear their own security, it's possible for another contracting party of the European Convention of Human Rights to raise that. And it has been before that that individuals from a country may lobby a country that's a member of the European Convention to pursue a case and to push for a case to be heard by the European Court. The court may receive applications from any person, non-governmental organization, or group of individuals claiming to be the victim of a violation by one of the high contracting parties of the rights set forth in the convention or to the protocols thereto. The high contracting parties undertake not to hinder in any way the effective exercise of this right. So anybody can apply to have their case heard, any individual. And I will tell you from what I saw of cases that were being submitted, the European Court of Human Rights gets daily hundreds, if not thousands, of handwritten letters from people citing a violation that has occurred of their human right in their jurisdiction. Oftentimes they'll send court documents to show that this case has been heard. But this is the problem, is that the European Court of Human Rights is flooded with applications from persons demanding to be heard. These people, oftentimes, even if they have a legal background, have not gone through the proper channel in their domestic courts. So from the get-go, the moment that document is received in Strasbourg, the registry will examine the stage that this case has gone through. And if they feel that this case has not even fully been heard, if it's in the preliminary level, or if it's not even been brought to the attention of the domestic court, that case is thrown out. So you have a two-pronged issue. You have a problem where the European Court is being flooded with cases that has no ability to hear. And you have a frustration of individuals in countries who are feeling as if the European Court is not listening to them. Again, it's administrative, it's bureaucratic. You have to go through your entire domestic. You have to completely exhaust your domestic channels before you come to the European Court of Human Rights. And when you are even when that requirement is fulfilled, when you're filing within the European Court of Human Rights, you have to file correctly. You have to follow the protocols. You have to file documentation. Sending a handwritten letter, as much as there is a desire for an official in the European Court to hear that individual's plea, that they won't be heard. So it's an issue of the court not being able to hear because administratively the process has not been met, and that individual's frustration. So that's one thing as an NGO, that you involve lawyers, that you involve people who have a familiarity with European human rights process of the court before you bring anything to the court. admissibility criteria. Remedies must have been exhausted, which are recognized rules of international law, within a period of 6 months from the date on which the final decision was taken. This is difficult. So within 6 months that the final court, let's say in Russia, let's say in Poland, has heard the case and issued a decision, that is your time period um, to bring a case to the court. Many consider that unfair. It oftentimes takes individuals longer to find the support. But at the same time, if you're aware of a human rights issue that is appearing in the courts in your domestic jurisdiction, you as an NGO dealing with those human rights issues should begin following it. You should begin at your lowest level court process and be trailing it and be collecting the documents that have been occurring, so that when it comes to this, to the 6-month grace period before you go to the European court, that you're prepared, that you have the legal preparation, that you've collected the documentation that you need to send to the European court for review. So no application shall be heard if it is anonymous. I think that's unfortunate in terms that if you're living in a country where, for example, there's retribution for raising human rights issues, you do still need to have a name on your filing. It can be the case of X, as long as the court is aware of the name, and they can keep it anonymous and you can request it, but the court has to at some point see who the individual, the name of the individual that is filing it. You as an NGO can support that individual. You can support their anonymity by going forward with the European Court of Human Rights and discussing the security risks, where the European Court will know the name, but that name does not need to appear on documentation. And again, as I keep restating, it will not hear a case that deals with issues that have already been a procedure of international investigation, settlement, and contains no relevant new information. The European Court of Human Rights will not rehear human rights issues. If that human rights issue has already been decided by the European Court of Human Rights, if it has already been examined, that decision is final. What you would need to be bringing to the court is a new issue, a new human rights issue which has not been decided, and then the European Court will take on your case.
Andrea, we have a question if you want to address it now. It was asked earlier. So the question is about Mikhail Lobov, who will become a judge at the European Court starting in 2022 from Russia. And he was chosen as one of the candidates by Vladimir Putin. This is the question reads. Also, for many, it's obvious that Russian judges are dependent on Putin, and this is contrary, this is against the convention. What do you think about Lobov, and what is his responsibilities in the European Court? And also, will he look at the claims from Russia? What's your thoughts on that?
So he has the ability to examine the claims that come from Russia, unless he in some way has been involved in that claim. So if at some point he was sitting in a court where that case came through, or let's say he has a financial interest. So if it's a case where, let's say a bank is being sued, but he's on the board of that bank, he in no way can appear. I would say that the strongest position would to be flooding the European Council with documentation about this judge. It's a flawed system, and you have exactly the same issues appearing at the United Nations on the Human Rights Council, where you have countries like China sitting on as a member of the 8 members of the Human Rights Council. So this is everywhere. There is an attempt, and that this is the clear motivation, and agree or disagree, that by including parties that you would not normally accept or believe could sit in these positions, is that you're bringing them in and you're hoping to affect change. So that's what the United Nations is trying to do with Human Rights Council. They're allowing countries that nobody would ever believe are sitting on in judgment of human rights, in the hopes that by exposing them to significant human rights issues that they could affect change. Now, I honestly believe that if you're able to, and I can assist in maybe bringing lawyers to your attention who are involved with the European Council, that at the point of nomination, that this documentation about this individual is sent to the European Council. It's essential, because if he's found not to be, I mean, I think I said at the start, their ethical character is a significant factor in whether they can be judged, whether they can become a judge in the court. So if there's any way to substantiate or prove that this person's ethical character is not of the highest standard, that should be brought to the attention of the European Council immediately. Please repeat this, Victor, the second question.
So I think you elaborated very well. It was mostly about your opinion on this person being, oh, I'm sorry, being a part of European court, and whether he will be reviewing cases from Russia. You answered that.
Okay.
And if you know what's going to be his general responsibilities in
well, it will depend. I mean, that nobody will know what level he would come in. Would he be on a lower level, or would he be a member of the Grand Chamber? So I mean, I think essentially at this point, if you are aware, and this stands for any member of the European Union is aware of something about this judge, that documentation that supports this, be it newspaper articles, decisions that he may have issued, anything that can put his ethical character in question or raise any issues about him, that should be submitted immediately to the European Council before his name is approved.
Thank you very much.
So, declaring inadmissibility of cases. First, the application is incompatible with the provisions of the Convention of the Protocols thereto, manifestly ill-founded, or an abuse of the right of the individual application. So now we're going to be discussing when an application is put forward. If it doesn't fall within the purview of the Convention of Human Rights, it won't be heard. So it may be an abuse that you believe is occurring, but it has to be framed when you file with the European Court of Human Rights in the terms of the rules of the European Convention of Human Rights. And a second part is that it has not already been decided. We have somebody trying to be admitted. If you want to, Victoria, I don't know. I don't know who it is, so maybe you want to admit or not admit. It's Kostiana. Okay. The applicant has not suffered a significant disadvantage unless respect for human rights as defined in the convention requires an examination of the application of the merits, provided that no case may be rejected on the ground which has not been duly considered by a domestic tribunal. Okay, so this is concerning the effect. If it was essential in the case of the Roma children, the lawyers representing Roma children in Croatia, to prove that by being put in Roma schools, that they were being disadvantaged. So it was essential for the lawyer to show how not learning Croatian, but residing in Croatia, the level of the schools, that they stopped at the high school level, the fact that the curriculum didn't match what was going on in the Croatian education system, all of that is a disadvantage to the individual who's bringing the filing the complaint has to be proven. And again, it has to be completely exercised through the entire domestic court system. So before this Orshus v. Croatia case came to the European Court of Human Rights, it had to have gone through all of the courts in Croatia, and the Croatian courts had to have found against the Roma individual who had brought the complaint. So two-pronged. One, that you have a damage, and two, that you've exercised all of your domestic options. The court shall reject any application which it considers inadmissible under this article. It may do so at any stage of the proceedings. So it is really up to the court to decide, are these damages significant? Is the individual seriously hurt by the law, by the actions of the country, and has the individual completely gone through their entire system? That is up to the court. That is the court's decision. Oftentimes, as I mentioned, it's going to be black and white, and it will be in the hands of the registrar to say, this is decided, you're not even going to progress to court. But at every stage of every chamber, that issue can arise and can be a reason for your case being thrown out. Third-party intervention. And this is, I've already discussed this, but in all cases before a chamber, any of the chambers or a grand chamber, high contracting party, one whose national is an applicant, shall have the right to submit written comments and to take part in hearings. So that means that a country, let's say, for example, Russia, can submit in terms of a case that's brought forward their comments and their position. That is a right that the individual country has when when a case is raised that raises issues within its own jurisdiction and its own courts. The president of the court may, in the interest of the proper administration of justice, invite any high contracting party which is not a party of the proceedings, or any person who is not an applicant, to submit written comments or take part in the hearings. In all cases before a chamber of the Grand Chamber, the Council of Europe Commissioner for Human Rights may submit written comments and take part in hearings. So here you have two levels. It can be the actual court that will reach out and say to Croatia, let's say Croatia doesn't submit anything or doesn't get involved in the Orshus case, they can go to them and say, so what are your comments? Please send us your filings. Please send us why you believe that this decision. But at the and identically, any person supporting the individual, any NGO, can be invited to submit documents supporting their client, supporting their side of the issue that is being brought before the European Court of Human Rights. Also, the final point is that the European Commissioner for Human Rights can submit documents, arguments in support of any side that has appeared and brought an issue before the European Court of Human Rights. So there's a place throughout this for both the domestic, which allows a lot of debate and a place, for example, for NGOs, a safe place for NGOs and domestic authorities to play out before the court. So the chambers at all levels have a right to hear from the parties, individual lawyers, NGOs supporting the person bringing the case, as well as the countries and the members of the European Council and the European Commission for Human Rights to battle out before the court their arguments. And the judges will take these into account. They will take amicus curiae briefs into account. They will take written arguments into account that are submitted on behalf of either side of a filing. The court may at any stage of the proceedings strike an application out of its list of cases where the circumstances lead to the conclusion that the applicant does not intend to pursue or pursue his application, or the matter has been resolved, or for any other reason established by the court, it's no longer justified to continue the examination of the application. So if in the meantime, let's say the legal issue, I'll keep using the Croatia case because it's something, it's specific, it's been decided, so we can examine it as a case and not get so much into domestic issues. But let's say while Orsic v. Croatia was being heard, the Croatian government, Croatian courts had decided, the Croatian government had changed its laws and allowed and disbanded and declared illegal schools for gypsies, for Romas. Then the issue that was at hand in the case would have been resolved. So the court would have stopped, let's say it had reached a midpoint chamber, it would have dismissed that case. Identically, if one of the parties stops appearing, stops filing, the court has so many cases, thousands of cases in backlog, it will drop the case and it will be up to somebody else to come back and raise those same legal issues because the court would dismiss it. So if the examination of the application is a human rights issue as defined by the conventions and protocols, and it's required that the case goes forward, for example, if it's a case of somebody who feels that their detention rights are being abused, that would be, and they die during this. So there's nobody to represent. So the individual who's the cause of it has passed away, but the court can feel that these are such essential issues of human rights that they will allow the lawyer and the amicus curiae and the NGOs to proceed with the case because it's such an essential human rights issue. So at the end of the day, what is the goal of the European Court of Human Rights? Upholding the European Convention of Human Rights. And they will put that ahead of everything. If they feel that the decision's been already, if the human rights issue's been resolved, they'll shut it and they won't go further. But if they feel that this issue is so essential to the European human rights structure, and something has happened, like this individual is not able to appear before the court, they may take their discretion and put the human rights issue that's being heard above a technicality and allow it to be heard. We are going to hopefully have enough time at the end of this to examine the International Covenant on Social and Political Rights. And that is really the document that lays out trial, what is a fair trial. And the European Convention of Human Rights also covers this. So this is something that internationally has to become essential. And I'm working right now, whether it is going to be a sort of an administrative court that will be hearing when a trial goes off the rails domestically and when detention is abusive, when there's not a fair, and you know, for example, I have been present in the United States when we were trying a case of a Liberian who was being prosecuted for immigration fraud, but really for war crimes that he committed in Liberia, where the judge, who was a federal judge, so she was in her early 80s, because it is a lifetime appointment in the United States, heard Liberian English being spoken and decided, well, that's the same as English, US English, British English, and she dismissed the interpreter. Liberian English is not equal to US English or British English. So this actually in their US court violated an essential element of the International Covenant of Civil and Political Rights, which the US is a signatory. Everybody has a right for a translation if they're not able to speak the language of the court. So the rules that you're going to be seeing from the European Court of Human Rights protecting are these rules, but it's something to keep in mind that these rules are being violated day in, day out in every courtroom. So there has to be a venue where only that is being examined and protected, and hopefully in the future there will be that. But the European Court has as its obligation to protect human rights. So if there is a technicality and they find that the human rights being violated is so significant, they do have the authority to keep the case going. So if an application was rejected early, let's say at the registry level, let's say that the registrar decided that there was some technicality that had gone wrong, the European court can re-examine that and restore its application. That would take an appeal. That would take an appeal by the lawyer showing how significant the human rights issue is, and that this error can't be allow for this human rights issue not to be examined. I will tell you right now, this is, I don't even, this is so rare. But you do have under Article 37 the legal right to keep pursuing an issue that has been thrown out at a very early stage, but it is extraordinarily rare. And I would count on one hand the number of times that it has been reversed and that it's been found that the administrative error of the person filing was so insignificant that the human rights issue outweighed it. Again, it's a European court, so they like bureaucracy. Examination of the case. This court shall examine the case together with the representatives of the party and, in need be, undertake an investigation for the effective conduct of which the high contracting parties concerned shall furnish all necessary facilities. If the case that has been brought to the European Court of Human Rights raises issues that are significant in human rights, but the domestic delivery of the domestic court shows that there has not been a full investigation carried out that resulted in the final decision of the domestic Supreme Court, the European Court of Human Rights has the authority to go further and work with high contracting parties to re-investigate the case. So they are able to reopen cases that have been decided under as far as the Supreme Court of a domestic jurisdiction. Friendly settlements. At any stage of the proceedings, the court may place itself at the disposal of the parties concerned with a view to securing a friendly settlement of the matter on the basis of respect for human rights as defined in the convention and the protocols thereto. Proceedings shall be confidential. If a friendly settlement is effected, the court shall strike the case out of its list by means of a decision which shall be confined to a brief statement of the facts and a solution reached. So at all points, everything shall be public. The decision shall be transmitted to the Committee of Ministers, which shall supervise the execution of the terms of the friendly settlement as set out in the decision. So if any point the country that the individual has found that his human rights have been violated, if they can reach a settlement and leave the European Court of Human Rights, and if it's proven that the country really is taking this seriously and it's going to carry out the agreement, the court can remove it. The court will, and it doesn't state this here, but the court, especially if NGOs are following the settlement, the court will keep an eye that the settlement is upheld. If it is not, the court can reopen that case. The court wants to settle. As I've said, it's flooded. There are too many cases at the European Court of Human Rights. If it can secure that a real settlement will be carried out, the court will be very happy to proceed with that. It will keep the facts confidential, but all NGOs who are involved in supporting a case that's brought to the European Court of Human Rights can follow what happens once the settlement occurs. And if the settlement is not an honest settlement, if there are breaches of it, the NGO, the individual, can reopen that case at the European Court of Human Rights. The hearings shall be public unless there's some exceptional reason for them not to be. It's the same, and you'll find the same in Europe, domestic courts, and you'll find the same in US courts if there is a matter of security. to an individual involved who's bringing a case, he or she can request that their case remain confidential. And then you would be hearing it would be appearing the case of X versus Russia versus Croatia versus Poland. You would not have their names revealed. So again, all of the filings are automatically public. And in my opinion, that's very important. The only time that you would ever be allowed to have documents not be confidential, remain confidential, is if there's a real life-threatening security issue for the individual who is filing, and they have to be able to prove that to the court, that it's essential for their security, for their well-being. Would they lose their job? Would their family be threatened if their names became public? Just satisfaction. The court finds that there's been a violation of the convention, and if the internal law of the high contracting parties concerned allows only partial reparation to be made, the court shall, if necessary, afford just satisfaction to the injured party. So if a party if it's only allowed that a certain amount of financial retribution under domestic law is allowed, that's what the court will reward that party. So just satisfaction means that it has to both uphold the European Convention of Human Rights. So the European Court would never allow a decision that does not afford the human right that's being alleged to have been violated to be protected. But at the same time, if let's say it's a financial resolution where domestically the maximum for a violation of this right is 500,000 euro, the European Court cannot raise that amount. It will fall under the country's jurisdiction as being the highest amount that the individual is due. Judgments of chambers. They are final. So the judgment of the final chamber of the Grand Chamber is a final decision, full stop. The decision of the other chambers, meaning that for example, if you're in a lower chamber and you attempted to go forward to a higher chamber and your appeal was rejected because that law has already been heard or because some administrative reason has not been completed, that becomes your final decision. In all accounts, the court can only overrule that if it is an issue of human rights that has been undecided and that has not been heard before. So the final decision is always based and should always be based on what does the European Convention of Human Rights order. If there is a human rights issue which has not been heard before by the European Court, even if there's a minor administrative fraction, it can be overruled. But if there's not, the final decision of the chamber that has heard your decision is the final decision. It can't go forward. And it cannot be appealed once it has been decided by the European Court of Human Rights that that's the final decision on that human rights issue. Referral to the Grand Chamber. So now we're going to look at if a case has merit. So you have a judgment in a lower chamber of the European Court of Human Rights. You feel that there is still a human rights issue that's outstanding and that has not been heard. It will, if you can prove that, move forward to the judgment of, will move forward to the Grand Chamber. But as with all Europe, everything in Europe, US is a little bit much more lax than this. You have timelines, you have rules. So it has to happen within 3 months of the date of the judgment of the chamber. So you have 6 months from your domestic decision to raise it within the European Court of Human Rights. And you have 3 months from the time that a judgment has been reached in the chamber for either party, the country that's being put in question or the individual who's raised the issue, have 3 months to bring that case for appeal to the Grand Chamber. The panel of 5 judges of the Grand Chamber shall accept the request only under the instance that it raises a serious question affecting the interpretation or application of the Convention of Human Rights or the protocols, or there's an issue of general importance. So if there's such a human rights issue that is somehow not covered within the Declaration of Human Rights or the European Convention of Human Rights, the Grand Chamber can examine that as well. So it is defined and limited by a human rights issue. And that is the only way that the Grand Chamber can hear a case. So if the panel accepts the request, the Grand Chamber shall decide the case by means of a judgment. Article 44 covers final judgments. The judgment of the Grand Chamber shall be final. There is no appeal to the Grand Chamber of the European Court of Human Rights. It's exactly the same as, for example, as much as any of you know of the United States Supreme Court. The only time that the United States Supreme Court, and we will see this because we're going to be examining how human rights cases get to the United States Supreme Court. So it has to be a brand new issue. It will not decide something that has already been decided. And the decision on that issue, once issued by the Grand Chamber or by the Supreme Court, is a final decision. It becomes final when parties declare that they will not request that the case be referred to the Grand Chamber. So it's possible that both parties at an earlier level decide that this is it for us. We're happy. I'm happy that you've made the decision. And let's say my country, let's say Croatia, has decided they don't want to pursue it any further and they just accept the judgment of a lower court. It can stop there. It doesn't have to progress to the Grand Chamber. Or B, 3 months after that decision, if either I or the country in question have issues that we feel have not been dealt with properly, we can then go forward and say that there is this essential human rights issue protected by the European Convention on Human Rights that still remains, and we are now appealing to the Grand Chamber. When the Grand Chamber can examine this, and it will refer it under Article 43, it will be published, and it will say the Grand Chamber requests this because it finds that this decision is final because it has dealt with issues that the Grand Chamber has already dealt with. It raises no new human rights issues. So therefore, there is no reason for the Grand Chamber to hear it. So the final lower level court will be the final decision. And that is the same you'll see when we deal with alien tort statute in the United States. If the Supreme Court decides that the federal judgment covers all of the issues concerning that law, the Supreme Court will not hear that. And the final highest federal level that it's reached will be the final decision on the matter. Reasons shall be given for judgments as well as for decisions. There has to be a public hearing where it is publicly written and decided stated why the decision was issued, and it will state why it's the Grand Chamber cannot just say, we do not believe that this covers European Court of Human Rights, European Convention of Human Rights, or does or does not. It has to state specifically what European human rights issue is raised here and why it has been decided before, specific cases that has been decided before. If any of these steps are not made public, there is always a ground for you to bring it up again and to appeal again and state that there is no public statement. This has not happened, I don't believe ever, but it is something to keep in mind that at all points of your work with the European Court of Human Rights, they have to be publicly either at a hearing, and of course, supporting that with materials, with decisions. You have to be able to see exactly why these decisions are coming out. There can never be any decision that you feel is arbitrary. case law has to be stated, as well as the actual human rights law that the court is upholding. It's also possible for there to be a separate opinion. And that is true in every United Nations court, US court, and the European Court of Human Rights. If there is a judge who does not agree with what he has stated and he's not part of the plurality, the judgment will be upheld, but you may have a separate opinion. And it is possible to refer to that separate opinion later on in a different case if you go come in forward for an appeal and say that there is a reasoning why these issues that this judge felt were not heard, and that in your case you support this dissent, this judgment that was made in dissent, and you go through the specific reasons that he gave. And if you can prove that you in a separate case are able to show this, and that you believe that the court should revisit this, you may have an opening. It's unusual, but you may be able to use a judgment delivered in dissent to support a future case. Binding force and execution of judgments. The high contracting parties undertake to abide by the final judgment of the court in any case which they are parties. The final judgment of the court shall be transmitted to the Committee of Ministers, which shall supervise its execution. The Committee of Ministers considers that the supervision of the execution of final judgment is hindered by a problem of interpretation by the judgment. It may refer the matter back to the court for ruling on the questions of interpretation. A referral decision shall require a majority of 2/3 of the representatives entitled to sit on the committee. So now here we are discussing what happens after. I'll again use the case of Oršić v. Croatia. So you have a case that's decided in favor of the Roma population. The decision comes to the Croatian government, to the education system, and nothing is done. The Amnesty International persistently complains directly to the Croatian government, consistently, and still nothing is done. What you have now and what is happening now in that case, and this is years, I'm sure these people are now in their 30s who filed this case as children. This is now being raised, and Amnesty is taking this back to the Committee of Ministers, demanding that the European Court reopens this case, and that the European Committee of Ministers takes this case against the country that is not carrying out the decision. This is slow, and I have so far made everything sound beautiful, as I believe that it all functions at the European Court. But I think all of you are aware that this is where it all sort of falls apart, that you will have judgments put forward by the court, and they're amazing judgments. They're public, they're printed in the New York Times, they're printed in all over the world in newspapers. And it seems like a great victory, a great human rights victory for the Roma population, for the LGBTQ population. But years go by in the country and nothing actually happens. It is so difficult to execute a judgment that it can take decades of the failure to keep circulating, and it really becomes a significant part of the NGO community to follow what happens once a decision is issued. Are the changes made? If they're not made, why are they not being made? Is there some sort of way that the NGOs can communicate to the national authorities that this is a failure? And if not, is the NGO strong enough? Can it get support from Human Rights Watch? Can it go to Amnesty to ensure that and many other NGOs? I don't want to just keep using those two, but to ensure that the European Court of Human Rights, the Committee of Ministers of the European Union are aware that a decision is not being carried out, and can we push for some sort of punishment, some sort of execution of that judgment. And it's tragic because for our next class, I'm going to go through and just write down the dates of Orshus and how long that Croatia has just ignored this judgment.
Andrea, we have a question regarding one of the previous points.
Sure.
So let me pull it up really quickly. I've got a bunch of windows here. Okay, so the question, if the case, for example, from Russia, is it possible, I suppose, for a court to require a reaccusing of a judge in order to avoid the event or partiality?
Yes, if it can be shown that a judge, let's say it has progressed midpoint, and we're in a midpoint chamber, and a judge is found to have some, let's say, private interest in one of the parties and is issuing a judgment in that favor, or even if he doesn't even issue any judgment, but you can show that there's something. Not only will that judge be recused, but that trial will restart. So you will have to have, let's say, midpoint. Let's say you're 8 months into a trial, and although European court isn't that slow, that's United Nations courts. But let's say a couple months into a hearing of a mid-level chamber, and it's exposed that a judge has some involvement. Not only will he be recused, but the entire case will have to start again in that level. So you'll have the hearing will start with a new judge starting from the start. If it's a recusal for health reasons or something where there's no bias, it's almost always likely that that judge will have to just read into the case. It won't restart again.
Thank you very much.
Okay. So the judges are also, and the European court can issue advisory opinions. So this would be an issue that's not being raised so specifically based on facts. So if there is an issue within the European Convention that the Committee of Ministers is dealing with, but it has not been raised as part of a case, the court can give an advisory opinion. This is also very, very rare. And I'd have to actually pull the last time that this was done. But it has to be voted on by a majority of the representatives to be decided by the court as standing as an advisory opinion. So once an advisory opinion, let's hypothetically say the issue of Roma, work rights of Roma in different countries, that they're able to take certain holidays. Let's say that's never raised within the court. The ministers can raise that, and it can be an advisory opinion can be passed. Now, does that advisory opinion become law? No, it just becomes a consideration that can be used by either side in a case that goes forward. It will have substantial weight because it means that it's been sort of attached to the European Convention. It does not have as much weight as an article of the European Convention, but it will be it can be cited to as within any cases that you're preparing. And again, because it's a majority, the European Court feels that it does encompass something that upholds the human rights structures and standards of the European Court. Yeah, and it's up to the court. I mean, at the end of the day, it's up to the court whether it feels, first of all, it may feel that this advisory opinion that it's requesting touches upon, I don't know if that comes up, it will come up later. The court doesn't want to issue an advisory opinion on something that it may be hearing. So that's the first reason. If it knows that there's a case coming up that deals with it, I think the court in almost all instances has decided to wait and to deal with it. Also, if the advisory opinion is completely outside of its jurisdiction, if it's not something that it feels that it touches upon the European Convention of Human Rights, it can say that it's not in a position to decide on or issue an advisory opinion. Like with the decisions, everything has to be public. You cannot have anything coming out of the European Court that is not substantiated and reasons given for that decision. If the advisory opinion does not represent in whole or in part the unanimous decision opinion of the judges, a judge is entitled to deliver a separate opinion. Of course, an advisory opinion, when it's issued with full unanimity, carries a greater weight than one that has a strong dissenting opinion. So if you have an advisory decision by the European Court of Human Rights that has a dissent that is extremely strong, perhaps two judges go with the dissent, then you will be able to cite to that dissent in any sort of future case that may raise issues that are raised in the advisory opinion. The advisory opinion, again, as with everything with the European Court of Human Rights, has to be public. It has to be published. It has to be available to everyone. Again, the only time that things aren't public are when there's extreme security issues. And in that case, they're always done, they're either redacted, so things are X'd out. So you have a black line through a name, a black line through anything that can identify a person or an issue. But in all other instances, everything is public, and that's essential. The Council of Europe funds the entire budget of the European Court of Human Rights. And under the Article 40, the judges are immune when they are sitting on, and this might interest you guys, excuse me, I have allergies here in the US because of your mentioning of this specific judge. Once he is made a judge, he is immune from numerous charges and issues that could take him away from his duties as a judge. But again, if anything comes up at any point that shows a question of this judge's ethical character, this has to be raised. And I don't mean rumor or anything. It really will take proof. It will take articles that are brought forward to the attention of the council. It will take, if possible, anything that you can show in terms of money being moved, money showing payments for decisions that are made, to have a judge removed from the court, or any sort of links between a judge and the government that he's being asked to judge upon and to issue judgments upon. Okay, there's a number of things. I'm going to put that aside. We're going to start talking, maybe we'll start next week with a discussion of something called pilot judgments, which is a process that the European Court has established. So if you have a number of cases in your jurisdiction that are identical, so you have 10, 15 cases that are dealing with an issue of, let's say, LGBTQ rights, and that there's a violation in different ways throughout the judicial system in your jurisdiction, you can request something called a pilot judgment. So the European Court of Human Rights can judge, let's say, 10, 15 cases at the same time if it finds that the issues are identical. And this is the first instance of this was based on a number of cases that came out of Poland. But I'm going to leave that because I think it's more important today that if we can conclude with, let me open that document and then screen share with now that we've learned how the European Convention of Human Rights is applied in the court, I want to go through the administrative processes on bringing a case. And in all honesty, this is where it all goes wrong. This is honestly where the majority of cases are thrown out. As much as the European Court of Human Rights wants to examine human rights issues, early on in the registry, technicalities are the reasons that cases never make it to being examined. As I mentioned, you cannot bring a case before the European Court of Human Rights until you've complete your entire domestic process. So for example, you have to go from the lowest level where the event occurred all the way to your national Supreme Court. Only then, when you're unsatisfied with your domestic court decision, can you come to the European Court of Human Rights. You have the 6-month deadline, as I mentioned. So you have from when your court makes the decision, you have 6 months to arrive at the European Court of Human Rights with your application and your filing. And there's all, it has to be filed in the forms and in the manner that the European Court demands. There has to be based on the laws of the European Convention of the Human Rights. And finally, it has to, you have to be able to show that the applicant has suffered a significant disadvantage. For example, Roma children not being able to receive an equal education to the children of the country where they're residing. So there has to be proof of damages, which would be the same in any other court in Europe or in the United States. One thing as an NGO to keep in mind is the 6-month deadline. If you are aware that a significant issue is rising up through your courts, be it like if you're working on issues of detention rights, if you're working on issues of LGBTQ rights, start following it from the start, already open the materials and documentation that you're going to need to file to the European Court of Human Rights and be ready. File as soon as you can, because it's going to put you at an advantage with the European Court of Rights if you're ready to go and you're not filing, rushing to get all your materials ready, and then perhaps missing your deadline. And that's a very common thing. Like, as I mentioned, documents were thousands and thousands of complaints are being filed at the European Court of Human Rights in improper form, in improper timeline. So these are technical things that can keep your issue from being heard. So the initial analysis is done at the registry level. It's done when it arrives. So the registry will examine the materials that you've submitted. You will have submitted it in the format that you can find on the European Court. And I will also, that's another thing I'm going to do. I'm going to put all of that, all of the admissibility documents and everything that are required. I'm going to file those and set up like a Google Cloud or something with Victor and Pedro so that we have that ready for you guys so you can look at that. It has to be in the right format, number one, first and foremost. You have to be showing, you have to be filing with the European Court of Human Rights your country's final decision. So you have to file with your country's Supreme Court or final court. If it, let's say it doesn't make it to your Supreme Court, it makes it only to your federal court, you have to, federal court, you have to show that and file that final decision to show that you've exhausted all of your domestic remedies and you're being forced to come to the European Court of Human Rights. You have to you cannot bring a complaint based on something that is not part of the European Convention of Human Rights. So know your European Convention of Human Rights. I will try to put a Russian version there for anyone who doesn't have it, because that's, you might think my right as, somebody who has, some sort of a handicap that is not, serious, that is not affected, or it's a housing right that's not protected as an individual right concerning maybe like rent changes or something that isn't significant enough to rise to the level of a human right. If you cannot find the basis in the European Convention of Human Rights, you will not proceed to the European Court of Human Rights. And again, damages. The judgment, if they find that there's a violation, so the registrar is the one who will decide that there is a violation that's occurred that was not decided by a domestic court, and that this violation falls within the European Convention of Human Rights, then you're going to proceed. It's possible that for numerous reasons that they can find that you filed too late. They're not going to hear it, that your complaint does not involve a European human right, and or that you've done something wrong, that there's been a technical error, or that your courts, domestic courts have not been exhausted, and there's an administrative fault. For these three reasons, your case can be dismissed. You can request for it to be re-examined. There is a second chance. Now, let's say it's something where the judgment goes already to from the registrar to a low chamber, and the low chamber says, as we've discussed, that this is a human rights issue that has already been dealt with by the court. If you feel that it's not, if you can have the legal proof to show that this human rights issue wasn't re-examined, that was not properly examined, that it's still outstanding, that there's a nuance. For example, if a decision dealt with LGBTQ issues in the workplace, but it's something concerning a domestic partnership, and that element of a human right is not part of what was decided, or you feel that the final decision on that human right doesn't cover your case, you can appeal. And that appeal, if it's accepted, continues to grow. It continues to go through the courts. Now, this second stage here, where it says final judgment finding a violation, final judgment finding no violation, that can occur at any point. It's only, and it can occur at any point because the higher court can say, can decide that the final judgment of the lower level of the European Court of Human Rights was correct, and it did cover the issues that were raised. It protected the human rights, the European Convention of Human Rights issue that was raised, and that all of the, and this, sorry, I forgot so that I'd have time to answer questions, so I'll go quickly, that all of the administrative steps were properly filed. So final judgment can come at any stage. Getting to the grand chamber is rare. It is extremely rare. And to get to the grand chamber means that there was a brand new issue under the European Convention of Human Rights, and this will be, the grand chamber decision will be the final decision on that. So what happens after? The decision is public, as I've mentioned. There will be hearing, it will be publicly transmitted from the judges. They will hold a hearing where they make public their decision, but there will also be a printed version. The printed case file is sent to the Committee of Ministers, and then the Committee of Ministers raises this decision with the state in question. So the Committee of Ministers says to Croatia, you've messed up. This was wrong. You violated the European Convention of Human Rights. You have to allow Roma children to attend national schools. So it becomes then, it falls back to the state in question. So that state's judiciary has in fact been overruled. The Croatian court had said it was fine what the schools were doing and the government was doing. And now the European Court of Human Rights has come in above it and said, Croatia, you were wrong. You now have to follow our decision. So there will be payment of compensation if, for example, if the Roma child can show that his future earnings were affected by not being able to have a fair education, he will receive a financial compensation. More important to the human rights community, perhaps not to the individual, is that the country, the state in question, has to show that it has changed. It will have to change, one, its laws. It will have to show that it is allowing, that it has made schools, specific schools for Romas, illegal, that that's not allowed. It will have to show that these schools have been closed. And at that point, it will send that back to the Committee of Ministers, or as is the case in Croatia, they don't send it back and it sits open. It becomes then the obligation of the Committee of Ministers to examine that case. And what has kept the Committee of Ministers involved in the Croatian case is the involvement of Amnesty International. Amnesty International has consistently been bringing forward to the Committee of Ministers proof of Croatia not executing the judgment against it. They have not shut these schools. They have not changed the legislation. So sadly, this is years now, and this is the problem. This is the problem with the European Court of Human Rights, is the realpolitik. And it is the truth that what will really happen is your case will be public. The world will know about it. The world will know what is happening in your country. They will know the violations. And that is the worst case scenario. That is what you're going to end up with, and that's what is going to be your end compensation for this. Best case scenario, your individual is compensated and your country changes. Your laws are changed and they reflect the European Convention of Human Rights, and your country has acted and stopped whatever behavior, be it running schools, be it discriminating based on gender, be it whatever your country, the reason for that state being brought before the European Convention Court of Human Rights is, that action, the legislation will have changed and those actions will have stopped. Final resolution. So it can work in certain instances, and I can pull up cases that I have prepared for us, where you'll see that countries, for example, the UK has changed its laws based on a decision of the European Court of Rights, and other cases such as Croatia that continue to act against a judgment that's issued by it. So that's the end of today's presentation. Like I said, next week I'm going to be going through specific cases. I have one case concerning Russia and Chechnya. The other cases are across the spectrum of Europe. We have a terrorism case from the UK. If you want any specific issues, because we're not going to be meeting again for a month. If you want any specific issues, I have one person mentioned last time, detention. I am going to be pooling cases that examine unfair detention and cases that the European Court of Human Rights has examined dealing with detention rights. So if there's something specifically, please email Victor as soon as possible, and I will pull up those cases so that we can discuss how the European Court of Human Rights has dealt with it.